Is there a definitive, authoritative, irrefutable primary source document explaining the operation of Article 8 and 9 of the Uniform Commercial Code and its effect on investors? Yes, there is. In 2006, lawyers for the New York Fed provided a detailed response to a questionnaire which was sent by the Legal Certainty Group in Europe, which was working to assure conformance to the U.S. approach and assure that secured creditors have priority over investor assets that are held in this indirect holding system in pooled form. So let's go into that response to the questionnaire. Here are some excerpts. First question, in respect of what legal system are the following answers given? Answer, this response confines itself to U.S. commercial law, primarily Article 8 and parts of Article 9 of the Uniform Commercial Code, UCC. The subject matter of Article 8 is investment securities, and the subject of Article 9 is secured transactions. Article 8 and Article 9 have been adopted throughout the United States. Question, where securities are held in pooled form, does the investor have rights attaching to particular securities in the pool? Now, in the answer, we'll see the use of the term entitlement holder. The concept of an entitlement holder or security entitlement had not existed in centuries of securities law. Securities were personal property up until the revision to the Uniform Commercial Code in 1994, in which this concept of a security entitlement was introduced, which severs property rights and converts the investor into a person with a contractual claim, which is very weak in the event of insolvency of the intermediary. So here is the answer. Does the investor have rights attaching to particular securities in the pool? Answer, no. The security entitlement holder has a pro rata share of the interest in the financial asset held by its securities intermediary. This is true even if investor positions are, quote unquote, segregated. Now, that's very, very important because it means that all investors, including sophisticated institutional investors, are subject to this as well, that segregation is of no effect in terms of being subject to this pro rata share of what is left in the pool. So segregation is something that is done in the books and records of the account provider. But at the higher level, when the securities are pooled, it is of no effect. And all securities in the United States are pooled at Depository Trust Corp. Question, is the investor protected against the insolvency of an intermediary? And if so, how? Answer, an investor is always vulnerable to a securities intermediary that does not itself have interests in a financial asset sufficient to cover all of the securities entitlements it has created. If the secured creditor has control over the financial asset, it will have priority over entitlement holders. If the securities intermediary is a clearing corporation, the claims of its creditors have priority over the claims of entitlement holders, the investors. Question, what rules protect a transferee acting in good faith? Now, transferee in this case means the creditor, the secured creditor. And in the answer, the word purchaser is used, but that is also the creditor. You will see from the context. Article 8 protects a purchaser, the creditor, of a financial asset against claims of an entitlement holder, the investor, to a property interest in that financial asset by limiting the entitlement holder's ability to enforce that claim. So let's read that again with the right words in there. Article 8 protects a creditor against claims of an investor to a property interest in that financial asset, in other words, in their own financial asset, by limiting the investor's ability to enforce that claim. That's shocking. So Article 8 protects the creditor against the claims of the investor. That's what it's about. Question: how are shortfalls handled in practice? Answer: the only rule in such instances is that the security entitlement holders, the investors, simply share pro rata in the interests held by the securities intermediary. Shortfalls occur frequently, but are of no general consequence except in the case of the securities intermediary's insolvency, which is really what we're concerned about here. Question: does the treatment of shortfalls differ according to whether there is fault, negligence, or similar breach of duty? And this is the shocking answer from the Fed. Regardless of fault, fraud, or negligence of the securities intermediary, under Article 8, the entitlement holder has only a pro rata share. So the purpose of Article 8 is to assure that even if there is fraud, that the secured creditors take the client assets. It's as simple as that. It's comprehensive. This is irrefutable analysis on the part of the Fed, and it's not conjecture that this is the case. So the legislation that is under consideration in the state of South Dakota is very important. And it is easily and simply done to restore the priority claim of investors to their own assets. This is the aim of this bill, House Bill 1199. It's very important, and I think you should support this bill. Thank you.